In addition to the questions that we are getting at the hotline about FEMA, we've received lots of questions about what should tenants do. I'm living in a hotel. Do I continue to pay my rent to my landlord? My landlord has removed all of my personal property, and I don't know where it went because he wants to repair the property, et cetera, et cetera. There have been lots of landlord-tenant questions here, so we have assembled an expert panel on landlord-tenant law to answer all of those questions and any others that you may want to pose to them. So we have Andrew Cogdell, who's the practice group manager of the Legal Aid of North Carolina Housing Practice Group. We have Roger Cook, who's a senior attorney. He does housing law, and he's in our Wilmington office. And we have Will Brownlee, who's the executive director and general counsel of the North Carolina Apartment Association, just to keep us honest. So, gentlemen.
Good morning. It's great to be here. Can you all hear me if I talk in this tone of voice? Yes? Okay. For me, at my age, that's always a concern. I'm just going to feel okay about this, even though about 20 of the 30 smartest lawyers I know in this state are in this audience. Interrupt me with questions. I'm going to try to make this worth your while. I'm going to be talking about fundamental principles where there's a private tenancy. And Andrew, my colleague, is going to follow to talk about the additional rights that would accrue when there's some type of subsidy involved, which is going to bring in some other principles and laws. But I'm going to talk about straight up North Carolina law. And I think maybe the first thing I want to say is, let's make sure that you're dealing with the person who's in a landlord-tenant relationship. If it's the child of the person who signed the lease, you probably don't have the right client. If it's the cousin of the owner of the home who's letting them stay there for some period of time with sporadic payments or a promise to pay when they can, you may not have a landlord-tenant relationship. So I guess my first statement to you all would be, try to get the right person. Try to know who you've got. I'm going to call this my wipeout and walk slide. I'm going to really be talking about three different scenarios when it comes to the issue of remaining in possession of the damaged premises. And scenario number one is where there's a virtual destruction, a wipeout of the premises. And under this general statute, that would mean that it would cost more than 1 year's rent payments to make the repairs. So the tenant has this statutory right to walk by doing those two things if there is that kind of catastrophic damage. Now, if you've got a written lease, which is not required, for tenancies of less than 3 years duration, it's not required, then those provisions will control if those provisions are otherwise in accord with North Carolina law. So this is the wipeout and walk scenario. I'm going to call this the not a wipeout, but the person wants to walk for whatever reason. And this would not necessarily be an option, but it may be an option, because if you don't have a written lease that delineates how to terminate, or if you have a written lease and it's at that point, a month-to-month relationship, but doesn't otherwise delineate, then you're going to have to refer to this statute, and it's going to give the tenant some leeway to terminate that lease in fairly short order, unless it's a year-to-year lease. So we've talked about where there's a wipeout and the person is going to go through a procedure. And I didn't state this, but there's a 10-day window on that, so that may be a hard one to pull off in some situations, depending on how quickly they get legal counsel. And then we've talked about the normal termination rights of a tenant under North Carolina law, unless a lease provides otherwise. And those were both I'm getting out of here scenarios. This is a I'm going to stay scenario. And then the question becomes on what terms. This kicks us into the requirements in Chapter 42 and in our common law for the owner to maintain the premises in fit and habitable condition. And the duty to pay rent is mutually dependent on that. Of course, you're not really allowed to withhold rent unless a judge says you can. But so we're in that realm here, and it's going to be about the tenant, I think, negotiating with the owner about what's reasonable. What is the actual fair market rental value of the premises in its damaged condition as a basis for the amount of rent that would be reasonable to pay. And that would be the legal basis for that negotiation. The case law interprets damages under that section of Chapter 42 to be the difference between fair market value as warranted in pristine condition and the actual fair market value. So we're going to look at the actual fair market value, and that would be the measure of rent for the tenant to seek to pay. And again, looking to that same set of principles, if it's damaged and the owner's saying, hey, I didn't damage it intentionally, you go ahead and keep paying me full rent, our case law would support an unfair trade practice claim against that owner. I've been talking about possession of the property so far, and I'm going to switch now briefly to talking about the stuff, the possessions, the personal property. I can imagine a situation where maybe there was a hole in the roof to begin with that the tenant had complained about, and it wasn't fixed, and when the storm came, the damage was a lot worse than it would have been if that hole hadn't have been there. So to me, that would be an exception to the general rule that the owner can't be held responsible for damages to the tenant's personal property caused by some act of God. So I think that would be an important fact to tease out, was what condition was the property in prior to the occurrence of the storm? And if in fact there were some problems there that had not been fixed within a reasonable time and the owner had been given notice, then there may be some liability on the part of the owner. I'm looking at folks who've litigated these issues through the appellate courts in this room and are well familiar with these principles. This is sort of black letter landlord-tenant law We have a statutory process of dispossessing a tenant, the summary ejectment remedy that's spelled out in Chapter 42, and that's mandatory. And that would apply whether there's been a storm or not. So if the owner wanted the tenant out and the tenant didn't want to leave, there's no right to simply go in and change the locks or what have you. The owner would have to use that statutory remedy. And also, any property that the tenant has would be protected from seizure by the owner. And again, the owner's violation of those duties would give rise to liability under this, Chapter 42 and also common law claims. I can't get to my last slide. It was the best one. There it is. Of course, the written documents may be underwater. So, dream on, maybe. Dream on. But, gosh, wouldn't it be great if they weren't? That's so helpful. So I'm not sure I have a real clear set of answers to give you, except open up a dialogue. These are the principles that I think would inform your negotiation with the owner representing the tenant. And hopefully the owner would be reasonable under the circumstances. That's what I got. I appreciate y'all being here. I appreciate you listening to me. Thanks.
Good morning. I'm Andrew Cogdell, and I'm an attorney with Legal Aid in Morganton, and I'd just like to thank everyone for being here this morning and helping us through this crisis. In contrast to what Roger talked about, I'm going to talk about disaster recovery options for tenants of federally assisted housing. First, I'm going to talk about housing with assistance that's attached to the unit, or otherwise what's known as hard housing. And that includes public housing, Section 8 project-based complexes, and USDA rural housing service complexes. Then I'm going to talk about the Section 8 Housing Choice Voucher Program, which is a tenant-based assistance program, or soft housing. And then finally, very generally, about disaster-specific assistance for federally assisted tenants. Most of the options that I'm going to talk about are very long-term. In the short term, most subsidized tenants, like private tenants, will have to rely on FEMA housing assistance in the short term to provide for their housing needs. And I have a handout, a one-page handout that was at the end of each of the rows that hopefully everyone will get. And that handout comes with a proviso that outline is a work in progress. You think with all the federal statutes, regulations, and handbooks that govern all the federal housing programs, that there would be a wealth of information about what to do in these situations in order to protect the tenant's entitlement to their federally subsidized housing. Unfortunately, there aren't. You have what little I found. And if any of my more learned colleagues in legal aid see any errors, omissions in my outline, please let me know so we can add to it so we know what we're working with. First, I want to talk about public housing. What's public housing? Public housing is the low-income housing that is owned and operated by a municipality. They receive HUD, low-interest mortgages, as well as operating subsidies that help keep the interest affordable to the lowest-income people. They commonly go by the names of Hickory Housing Authority, Morganton Housing Authority, Raleigh Housing Authority. And unfortunately, they're frequently derogatorily known as the projects, but they provide a large bulk of the housing to our clients. Although it's the most protected housing entitlement with an extensive grievance procedure, the options for tenants in a disaster are very limited. The tenants either have the right to transfer to another unit if one is available, and if not, if they're displaced, they merely have the right to return to that unit when it's restored. Nothing beyond that. So again, those folks generally have to rely on FEMA housing assistance that we talked about earlier. Another type of housing is Section 8 project-based housing, and that is privately owned housing that has HUD mortgages as well as subsidies to make the rents affordable, again, to very low-income clients. And surprisingly, although your right to that housing is somewhat tenuous, it has the most extensive options available to tenants during a disaster. And that's due to a HUD notice that was issued in 2004 and was subsequently incorporated into the HUD Asset Management Handbook 4350.1. And Chapter 7 and 38 of that manual cover these situations. And I'm going to touch on some of the highlights. And those materials are all online with the other materials that the Bar Association has posted for us. Along with the right to transfer to another unit or return if you're displaced, residents in these complexes have the right to priority on the waiting list at other Section 220D or Section 236 complexes. So, for example, if you live in a complex that is heavily damaged by the flood and you have to leave your unit, if there are 5 or 6 other Section 8, 221D3, or 236 complexes in your area, you're entitled to jump to the top of the waiting list in any or all of those complexes, wherever you apply. Another option is, and this is a bit odd, but current residents may house displaced family and friends in their units on a temporary basis. And me, along with my colleagues in legal aid, probably find this surprising because ordinarily these landlords strictly enforce their occupancy policies. Most of them have a rule that you can't have a visitor stay for more than 14 calendar days in a year. And the fact that they have this flexibility to allow guests to remain in their apartments indefinitely is quite unusual. And along with allowing these guests to stay in the unit, the displacees must execute a 30-day renewable lease, which is terminable once the permanent housing is available. So that may raise some interesting questions when the permanent housing becomes available again and these temporary tenants don't leave. I'd argue that since they do have a separate lease, if they don't leave, the landlord's obligation is to evict them alone and not evict the permanent tenants of the unit. And more importantly, when they do evict the temporary tenants of that unit, particularly when it comes to seeking a writ of possession to have the household members evicted, that it only be limited to the temporary lessees and not the permanent ones. Another option for these landlords is something called a Section 8 pass-through lease. And that is a situation where if the unit is rendered uninhabitable, they're not going to get the subsidies from HUD for that unit. But instead of letting that subsidy lie around, they can take that subsidy and use it to rent another unit on the private market for a displaced tenant, which is, in our mind, extraordinary. Also, if the complex is damaged, destroyed, or condemned, its subsidies can be transferred to another complex. And if that happens, then the current tenants of that complex have the right to move to the new property. Additional relief for tenants in these complexes or to other displacees is that the landlords can hold vacant units for FEMA certified displacees if there are no priority applicants. They're also allowed to use community spaces for disaster shelter initially. They're also allowed to waive occupancy restrictions during a disaster so that these temporary tenants can share these units with permanent residents and not be evicted for exceeding the occupancy requirements. And finally, displaced tenants must be given a reasonable retirement term to return to their rehabilitated units. The next type of housing I'd like to talk about is USDA, or Rural Housing Service housing. And that is rural housing that has a USDA mortgage and either Rural Housing Service or HUD subsidies to make the rents affordable to the lowest income tenants. And there, the tenants also have a right to transfer or return if they're displaced. But they also have the right to receive what's called a letter of priority entitlement. And what that is a letter that is issued by the USDA, and it gives these displaced tenants priority occupancy nationwide on a first-come, first-served basis and any other USDA multifamily housing project. So what it does, just like in the Section 8 project-based program, it allows these tenants who are displaced to move to the top of the waiting list at other USDA complexes. These letters of priority entitlement, or LOPE letters, are good for 120 days from the date of issuance. And this may present possible opportunity for some households in that it may allow them to move closer to family elsewhere or move to what they may perceive to be more desirable complexes. The last type of housing I'd like to talk about is the Section 8 Housing Choice Voucher Program. And that is the tenant-based subsidy program in which the participant uses the subsidy to rent a unit on the private market. And in disaster situations, this is the best option for tenants because that voucher is either transferable or portable. And what do I mean by that? Well, first, if a tenant lives in a private unit and the unit is only damaged but it's repairable, then in that case the subsidy can be abated until the unit is renovated. Once it's renovated, the subsidy starts again and the tenant can stay in the unit. If the what they call the housing assistance payment contract is terminated because of the extensive flood damage and the unit can't be repaired, then the participant or the tenant of the unit has the right to transfer the voucher to another unit either within that jurisdiction, or they have the additional right to port it or take it to another jurisdiction and apply it to a unit there. Participant in the Section 8 program has 60 days to apply a voucher to another unit with possible 30 days extensions. And that may be problematic in a lot of these areas where a large part of the low-income housing stock was lost in the floods. And hopefully, or it'll be up to us to advocate with these Section 8 programs, Section 8 agencies that administer these vouchers, that they need to be flexible and considerate of these circumstances in granting extensions. In my research, I also found some anecdotal evidence that a PHA may possibly allow the use of an abated voucher to make payments for temporary housing elsewhere with the same landlord. My thought is, in most cases, if the landlord is allowed to do that, that generally will turn into permanent housing. Last, I'd like to talk about other disaster-specific assistance. And like in other disasters, it's likely Congress may enact legislation providing funding for additional assistance in response to this particular disaster. For example, there was Katrina disaster rental housing assistance or disaster vouchers which were funded in response to Katrina and the unprecedented loss of federally assisted units there. More recently, Congress appropriated $500 million to HUD for assistance for victims of the flooding in Louisiana, Texas, and West Virginia. North Carolina just missed the deadline for inclusion in that allocation, and it's likely that, or we're currently awaiting separate action for funding here. Another thing that is posted in the materials online is a PowerPoint entitled Disaster Preparation, Response, and Recovery for HUD Grantees and Tenants. And that PowerPoint contains excellent directions to how to provide for addressing the needs of federally assisted tenants. But unfortunately, the PowerPoint didn't have a lick of authority or a single citation for authority for doing all the things that they do. But the one thing that jumped out at me in that presentation was it said that HUD's long-term goal is to ensure that all displaced tenants are in permanent housing equal in quality to what they had before the disaster. And I think they do that in several ways. First, there seemed to be a lot of relief that's provided on an ad hoc basis based on the cooperation between HUD and the various housing providers or among the various housing providers in a jurisdiction. And as far as funding, Madeline's circulated a press release from HUD from November 16th, and it's entitled HUD Housing Disaster Assistance Reaches North Carolina Hurricane Matthew Survivors. However, it said very little about what funding, or it's ambiguous as to what funding assistance HUD may now make available to survivors of federally assisted housing. The press release states, HUD disaster-related services for North Carolina include disaster assistance for those who lived in public housing, a Section 8 unit, or have a housing choice voucher. Survivors should contact the housing provider that assisted them before the disaster or contact HUD. As I say, that tells us next to nothing. And I actually called the HUD number, and I actually talked to someone after I got through their maze, and I left messages for 2 people that are supposed to be working on this, and I haven't heard back from them. But once I do, and I know some specifics about what money is actually going to be made available to assist federally assisted tenants who have been displaced from their units, I will pass that information on to everyone. Any questions? Okay, thank you.
Good morning, everyone. This is a very sensitive microphone. Can you hear me clearly? Usually I have to scream into microphones. It's very different for me to almost whisper into one. So thank you to the bar for excellent audio. My name is Will Brownlee. I am with the Apartment Association of North Carolina. I serve as its executive director and its general counsel. George was very kind to ask me to come, possibly anticipating something of a contrarian view to these fine gentlemen I've worked with before. I just am going to speak to a bit more of expansive discussion of North Carolina landlord law, following Roger Cook's excellent lead. Just a couple of points. I don't have a PowerPoint presentation, so I'll just walk through it. But Roger mentioned a strategy when you find yourself in a disaster as a tenant to basically drop it and walk away under Statute 42-12. And that is certainly an excellent option for folks who find themselves in a disaster and don't want to stay around for the rebuilding, nor do they want to. There is one concern coming from the landlord point of view, of course, which is in a disaster like that, one thing that is often missed or left behind is the personal property of the resident that may have been involved in that disaster. Of course, most of that personal property in a flood like the one we've had could be completely destroyed. It may be virtually valueless, and the resident may not even want to claim it or take it with them. But from the landlord's perspective, the landlords, or at least the ones who care, are always mindful of a statute called 42-25.7, and many of you may be familiar with that statute. It's entitled Distress and Distraint Not Permitted, but the main push of that statute says that the landlords of residential rental property shall have rights concerning the personal property of the residential tenants only in accordance with, and then I list 5 statutes. And I'll save you the trouble of reading through those 5 statutes. The 5 statutes, the very first one refers to an abandonment statute that's located under 25.9D, but that abandonment statute is not very useful for landlords to use because it only has a ceiling of $750, requires donations to a charity, requires the charity to hold it for 30 days, and no charity is going to receive a bunch of sopping wet, destroyed property. The other 3 of the 5 statutes refer to a post-eviction remedy, and then the 5th one talks about a very narrow estate remedy for a tenant who dies alone. That is going to corral most landlords into being cautious, and if the issue of personal property is not taken care of or unanswered, the landlord may have the only remedy of filing an eviction in order to get legal rights to remove the property at the end of that eviction through a writ and a lockout. And you're probably wondering, that seems like an incredible waste of time. They're terminating their right to stay there under 42-12. They're walking away, but again, the issue is going to be what is done about the personal property left behind. It's sometimes a missed piece. As a practical piece of advice, it's really just a matter of contacting the landlord if you're representing the tenant and just making clear what pieces of personal property that the tenant wants to take with them, and for the remainder, some sort of quick release. It could be nothing very fancy, maybe a 2 or 3 line acknowledgement to the landlord that our client doesn't want the rest of the property and the location. It provides that simple act provides 2 very nice things. One, it provides comfort to the landlord who actually knows what to do with it now, and also provides your client free from a frivolous, should be needless summary ejectment lawsuit on their record, which should have been avoided by a simple 1-page document to say you can have the property, or I just want to pick up a couple pieces, grandma's old Bible, this piece of undestroyed piece of personal property, you can take the rest. Just that one piece of paper could have big implications. One other item as well, and for many of you who practice in this area, it's probably par for the course. But one thing that's often missed by residents who are leaving in the event of a catastrophe is that they may forget about a security deposit that's left behind. It may just be a minimal security deposit, it may be a $50 or $100, but in the case of a catastrophe, especially subsidized, excuse me, that's a lot of money. And every dollar counts. Could go toward food and other supplies. Sometimes they'll forget to leave us something as simple as a forwarding address to the landlord, because when somebody's displaced by tragedy, it's hard to know where you're going to end up. If they could take the time to give a forwarding address for a family member, a concerned friend, that would go a long way. By giving that to the landlord will know where to send it. Also, on the flip side, if they've taken the time to give the landlord that address, it makes it that much more actionable if the landlord fails to return the deposit in all of this catastrophe. So either way, I think you help your client a great deal by taking that one additional act, telling them where they're moving, or if they're very fluid, they may be moving to hotel, to temporary shelter, etc., at least the address of a family member or friend that it can be forwarded to. That will have great benefits to your clients as well. I want to make sure I don't go past our time. I was taking notes while you gentlemen were talking, so I want to make sure I didn't miss anything. And last but not least, going back to the disposal of personal property. On the flip side, there are landlords who may assume that they have the right to touch the property. When the tenant vacates, moves out after a catastrophe, that of course, since they didn't claim it, they have the right to touch it. Under 25.7 and under 42-12, there really is no clear path to that for a landlord to do that. And a number of landlords will not attempt the remedy that I described earlier. A number of the smaller private landlords who aren't trained or educated will just think it's their property to seize. Christmas came early. So to speak. They may walk through, pick through the unit, find the nicest pieces, throw away the rest. That's actionable, I believe. I believe you may have claims of action against. So the landlord will have to be respectful not only of the catastrophe that's happened, but also of the personal property that may be left in the unit. Even if it's seemingly destroyed, it may have value to the resident. And if the landlord decides to clear it out, move on, start rebuilding without asking the resident, that may be actionable, and there may be damages flowing from that. The only catch to that, though, is under the statutes, the only real damages that can be sought is for damages for actual damages, and you may find with your clients that the actual damages are rather minimal if it's all destroyed and the value of zero. But there's almost always something, even in a flood, that has value. And it's something that can be itemized, can be brought to court. And that is something to consider when representing your clients. Don't let go of the personal property. It's very important. I don't need to tell you that, I'm sure. That's all I really had. Are there any questions that you all may have? Of me or the panel? Okay, thank you. Thanks, George.
Thank you, that's it. Any last questions for the group? Thanks again, guys. Thank you, appreciate it. Thanks, Will.
Yes, sir. Thank you.
I will note that we did give templates. Will talked about notice to the landlord. We have given sample tenants to the hotline. Brooks has them. We'll make sure that we get copies of those templates so that you can notify landlords in the event you have to do that on security deposits, on constructive eviction, on all the things that they mentioned. And if you just call us as well, Andrew or someone, one of our housing advocates can get you that.